All right. Well, I think we'll get started and welcome everyone. Thank you for joining us in this third session of our webinar series, PRC Power Abroad and the Guardrails We Need. My name is Elizabeth Donkervoort. I'm a senior advisor for China programs with the Asia Pacific Foundation of Canada. For those of you who are joining us for the first time, this series was designed with a straightforward idea that navigating Canada's relationship with the People's Republic of China, or the PRC, requires a much deeper understanding of how Beijing actually conducts its foreign affairs, the tools, the tactics, strategies, and objectives that it's using to achieve its interests. We've spent the first two sessions on influence operations more broadly, as well as the strategies underlying the Chinese Communist Party's economic statecraft. Today, we're going to turn to a more nuanced area of these elements, which is lawfare. And I will leave that up to our speaker to define what lawfare is. And we'll be looking at this idea of lawfare through the lens of Hong Kong, which is one of the most instructive and sobering case studies available. With that, I'm really pleased to invite our speaker, or introduce our speaker, Dr. Eric Lai, who is a senior fellow at Georgetown University's Center for Asian Law and author of Legal Resistance Under Authoritarianism. Dr. Lai is going to examine how Hong Kong's common law system, which was once treated almost like an institutional firewall to the party-state governance model in the PRC, has been dismantled, and the role that legal professionals played in Hong Kong in efforts to resist that unraveling, and what the limits of that resistance reveal about the vulnerabilities of legal institutions to sustain the vulnerability to sustain political pressure. We saw last week, or in the last session, how Bethany Allen discussed the limits of neoliberalism as it related to sustained authoritarian pressure. And so today we're taking that into a new lens through the legal system. These are not abstract questions for Canada, and I think our conversation today will make that clear. Now, just a few logistics before I turn it over to Dr. Lai. Please put your questions in the Q&A function throughout. We'll get to as many as possible in the final portion of this session. Now, this session is also being recorded and will be posted on the APS Canada website, along with a summary report for this discussion. Similar ones for previous sessions are already uploaded if you missed them. And finally, this is an ongoing series. We have a fourth session coming up next week, but we really want to hear from you about what you want these sessions to cover. If there are topics you'd like to see and to analyze, experts you'd like us to interact with and having a chance for you to engage with, please let us know. We'll be sending a feedback form after this session is over, so please do take a few minutes to fill that out. Now, with all of that, I am going to turn it over to you, Eric, for a 20-minute presentation.
Thank you, Elizabeth, and thank you everyone for joining this webinar. I'm delighted to share some of my observations and findings related to the China's lawfare in the case of Hong Kong. And I'm very grateful to the Asian Pacific Foundation of Canada for this webinar series, and which would help, I'm sure confidently would help our audience to better understand the current state of China's governance within its territory and beyond. Let me share my screens for our convenience. Great. When we talk about the rule of law, it's always about whether a legal system adheres to certain values that protects not just basic human rights, but also protects the interests of the community, and which in such interests of community is often translated to limiting government, to limit executive power, to prevent power abuses, to install checks and balances, separations of powers, and to ensure fairness, equity, and legal certainty so that were ranging from citizens to businesses to countries, that they could adhere to a certain norms and rules that they could follow to ensure stability as well as prosperity and ultimately equality and freedom. Of course, rule of law is not just about human rights, but without human rights protections, without protecting citizens' interests against abusive state power, hardly can we refer to a situation that rule of law exists. And contradictory, in contrast, the PRC's lawfare is acting opposite to the values of the rule of law. The use of laws and judicial instruments aimed to serve a discretionary or arbitrary power exercise of the executive branch of the government. By undermining the judicial and legislative authorities, which in a way undermines separation of powers, China's lawfare does not simply target its own citizens, but also impact its partners in the globe. If we take the case of Hong Kong as an example, sometimes we find some mixed feelings or mixed observations, because on the one hand, we could see Hong Kong has had a robust rule of law and judicial independence inherited from the British colonial regime, where the common law was introduced into Hong Kong. However, on the other hand, Hong Kong is not a sovereign state, and the sovereignty transfer on the 1st of July 1997, where Hong Kong's sovereignty was transferred from the British colonial government to the PRC, meaning that China remained the ultimate power, the ultimate sovereign power over the governance of Hong Kong. In the early days of handover, China and Hong Kong entered relationships that was to a large extent in harmony, in stability. Even though there were local oppositions, there were local mobilizations against government policies or legislative proposals, to a large extent, the pre-existing mechanisms in Hong Kong, including the legislature and the judiciary and other independent bodies, worked well. The turning point started in 2019, and in 2020, China's imposition of the national security law made Hong Kong entered into a new stage of its one country, two systems. The national security regime was installed by the introduction of the Hong Kong national security law by Beijing. And eventually, in the past 5 years, we have witnessed a lot of shifts in institutional developments. Some may call it a paradigm shift. Some may call it a fundamental change to one country, two system. Some may say it's the beginning of the autocratization processes in Hong Kong. But ultimately, in effect, we could see Hong Kong, once it was a liberal jurisdictions with a high degree of autonomy and a partial but more progressive democratic developments, has been reversed to an illiberal or autocratic practices surrounding in this city. Few months ago, Jimmy Lai, one of the key figures among the national security criminal defendants, he was convicted and sentenced to jail for 20 years as he was convicted for colluding with foreign forces. One day after Jimmy Lai's convictions, as well as his former colleagues' convictions, Beijing State Council released a white paper on Hong Kong. And this white paper was, if I may transfer, which may not be a very literal translation, is the implementations of what safeguarding national security under Hong Kong's one country, two systems. This white paper was the third white paper related to Hong Kong since 2014. And this white paper, apart from praising the so-called achievements of safeguarding national security in Hong Kong, it also highlighted new security domains, including shipping, finance, economy, and these areas shall be deemed as a new front for safeguarding national security. On the other hand, it also emphasized the need to counter overseas mobilizing forces that may impact on the local community. The white paper explicitly highlighted that overseas groups with propagandas or slogans like freedom, human rights, and democracy, these are dangerous forces that may have their agitating activities bringing back into Hong Kong. And therefore, we can see, even after 6 years of the imposition of the national security law, Beijing still wants to emphasize security governance into Hong Kong, in this city. And the top imperative of safeguarding national security remains. If we take the case of Hong Kong as a reflection on the do's and don'ts for our friends abroad, I guess one fundamental issue is why Hong Kong is a significant case study, or whether Hong Kong should be examined as a critical case study that we can draw lessons on. Hong Kong's one country, two system, some may say it's a unique model, but some may also say it's not so unique in the course of Chinese history. On the 1st of July, 1997, Hong Kong's sovereignty was transferred from the British administration to the PRC. And the PRC established a special administrative region into Hong Kong, claiming that most of the pre-existing institutions in Hong Kong would remain, except two. One, Hong Kong would ultimately enjoy the final adjudication power. That's why they set up the Court of Final Appeal, and the Privy Council in London was no longer the final authority of Hong Kong's common law system. And the second unique or exceptional arrangement was that Hong Kong could enjoy full democratization under the Article 45 of the Basic Law. It meant that the people in Hong Kong could select their own chief executive and the legislature by democratic practices, by universal suffrage. However, all these two promises were eventually faded, since, first of all, in 2014, Beijing refused to allow Hong Kong to enjoy a full universal suffrage. And second, even though Hong Kong has a Court of Final Appeal, there were many instances that Beijing would intervene in such final adjudication by interpreting clauses and provisions in the Basic Law, and ultimately shifting the judicial outcomes. And the imposition of the national security law in 2020 was another watershed turning point to change Hong Kong's common law system to a large extent. To understand Hong Kong's one country, two system, we may need to refer to the historical root of China's central peripheral governance. Some scholars have already been arguing that Hong Kong's one country, two system was not unique because there was an earlier model after PRC took over China. There was this Tibet model in 1950s. At that time, the PRC government also arranged a one country, multiple system model with Tibet through the 17th agreement with the Tibetan authorities. At that time, there was Dalai Lama who were presiding in the authority. But eventually, history told us that Beijing eventually took over of the administration of Tibet, and eventually that separate system in Tibet was gone. I will not go into detail because of limited time, but it's more important to highlight that Beijing, for the PRC government, when they govern Hong Kong as a peripheral regions, they are not using the mainland system, but one country, two system model. But that one country, two system model was transitional. Ultimately, from historical perspective, all this separate system model is to give time to the authorities to assimilate its own system, to assimilate the peripheral system into its own central governance system. And And that's how the central peripheral relations worked in the Qing dynasty, and as well as in the PRC regime since 1949. And this model was sometimes called by scholars as 天下 model or 天朝主义. And some observers even highlighted this model is reviving in mainland China when a system of tribute system now exists, as some observers suggested in recent days. So back under this one country two system model, we need to pay attention to two fundamental principles that how such one country two system works. The one country two systems in Hong Kong worked mainly because in the first place, the tolerance of the sovereign state, which is China. As long as they accept one country two system to remain vibrant and to remain attractive, that they would tolerate of the local people working within the one country two system model. And Beijing, in the past, before 2020, to a large extent, they have been accepting the importance of fulfilling, complying with the basic law and with the one country two system model. However, if the authorities refuse to comply with the one country two system model, and there is no other external mechanisms, there's no other external bodies that could prevent interventions or abuses of power by the sovereign state. And the Lawfare, PRC's Lawfare in Hong Kong, I will argue that have been operating in two phases. Before 2020, the Lawfare was mostly operated in a way to contain or to tame the judiciary by various surrounding forces, including co-opting with legal elites, including the use of British colonial laws, as well as transplanting the PRC-style legalistic route into Hong Kong, such as the use of the basic law interpretation powers to try to influence judicial outcomes, as well as introducing mainland narratives on laws and courts into Hong Kong to try to influence or to pressurize the local judges. And examples include the white paper in 2014 that the PRC authorities asked all judges to be patriotic, to be loyal to the country, rather than being upholding its independence as adjudicators, as neutral arbiters. And at that time, before 2020, what were the main purposes for China's lawfare in Hong Kong? I will argue the objectives are in threefold. Of course, is to suppress political dissent. There were outstanding political figures that have been suffering from the lawfare, from the weaponization of laws and courts in Hong Kong, including Joshua Wong. These figures have been imprisoned in Hong Kong when the government employed the colonial laws for political suppressions. But more importantly, at that time, the Chinese authorities aimed to expand its party state's apparatus influences into Hong Kong via such lawfare. And this use of laws and courts were not simply driven by the political authorities, but they also need local elites in order to consolidate its ideological commands and ideological narratives related to laws and courts of Hong Kong. And the main contention between those narratives were separations of powers, which is a very fundamental values in Hong Kong's legal system in the past, versus the PRC ideas of cooperations between three branches of power, ignoring the importance of judicial independence, as well as legislative accountability and legislative autonomy. Apart from that, what's more significant was the fact that Beijing has been successfully co-opting with local ego elites in order to consolidate its united front strategies into Hong Kong's legal system. When we talk about the legal system, we are not simply talking about the legal architecture or statutes or the mechanisms, but we're also talking about the actors working within the mechanisms. So who are the actors? Apart from the government, apart from the judges, then lawyers, legal professionals legal professionals are the significant stakeholder in the system. By co-opting with legal elites, co-opting with lawyers, I'm referring to the fact that Beijing has been trying to open the legal service markets in the mainland to try to attract the local legal service industries in Hong Kong to incorporate with the mainland's market. And on the other hand, by introducing Chinese capital into Hong Kong since 2004, the rise of companies eager to be listed on Hong Kong stock market has also created a huge demand for legal service in Hong Kong for these mainland companies for IPOs. And therefore, we could see there was a strong sense that the legal service industry has been undergoing a lot of pressure, not just from the political authorities, but also from their clients from the mainland, that they were not eager to try to openly criticize or to challenge Beijing's intervention into the legal system, but rather the mainland authorities as well as their clients will become a key condition or key backdrop for the lawyers, for legal professionals to remain politically neutral, but in a way, such neutrality was favorable to the state to introduce illiberal or anti-rights narratives of laws and courts and or anti-rule of law narratives into Hong Kong. So after 2020, when the national security law was introduced amid the 2019 anti-authoritarian protests, new laws and new offences has been imposed in Hong Kong, and hundreds of political figures and journalists and political dissent were arrested. Human rights organizations, civil society organizations were disbanded, and hundreds and thousands of local people have left the city to relocate to other countries, including Canada, for settlement, as a way of exodus. And what are the post-2020 lawfare in Hong Kong? I would say is an enhancement of the lawfare before the imposition of the national security law. Apart from setting up new security laws and enforcement bodies, actually what's more important is the enhanced social control by introducing more legislations and more regulatory mechanisms into Hong Kong. And these mechanisms, although they are not a direct legislation under the national security apparatus, but this also expanded the local executive bodies to regulate different sides, different rims of society in the name of safeguarding national security. In a way, it creates a new surveillance regime and expanded the authorities abroad when they introduced new extraterritorial clauses in those security laws to target political dissent and foreign forces, which they in their definition, foreign forces are not just including political authorities abroad, but also any actors that have a foreign element. And using the courts to legitimize PRC aligned narrative and ideology has become a new tool. For example, in recent verdicts related to national security trials, the judges are almost fully adopted the government narratives on portraying political dissent and portraying the social events as threats to national security. And all these use of narratives are endorsed by the court and become legitimized and become recorded in those legal verdicts, which become an official narrative and endorsements. There are new laws and regulations in the past 6 years, and these new laws and regulations are not aiming at limited government powers, but more serving as enabling the authorities to introduce more regulations and more compliance requirements to different social actors. And the latest development was just happened a few weeks ago when the Hong Kong government introduced a subsidiary legislation that allows the chief executive to count on any offense as a national security offense, and such trials will enter into a national security criminal proceedings that no juries could. The governments can remove juries, the government can assign and can handpick judges to adjudicate those cases, and limited due process rights and fair trials are installed. And to conclude, and all these practices are serving at one goal: to enable the governments to do whatever they want, and to create a new boundary risk that the boundary could always be flexible, could always be discretionary upon the government's will. And given the one country, two system model is highly depending on the sovereign state, which means it's the PRC, it is really pessimistic for everyone living under such model to react or to counterbalance the influences of the sovereign power. And such lawfare would be useful in such settings, but whether this lawfare will expand beyond to its overseas partners, and I guess we could discuss further in our Q&A sessions. Thank you.
Eric, thank you so much for that whirlwind tour of complex topics such as lawfare. So using the law as a tool to repress or punish or otherwise achieve a political end, as well as the complicated recent history of Hong Kong and its interactions and relationship with the PRC. There's a lot of different directions that we could take this conversation, and I will look forward to the Q&A. We're going to have about a 20-minute discussion between Eric and myself, but for those of you in the audience with questions, please start putting them in the Q&A so we can think through how we're going to ask them to Eric, and we'll try to get through as many as possible. So Eric, I think where I'd like to start right now is looking more at how these changes specifically in Hong Kong will be impacting Canadians, Canadian organizations, academics and whatnot directly. So what's happening in Hong Kong, because Canada has a significant institutional footprint in Hong Kong. There's 5 major banks and more than 150 insurance companies have operations in Hong Kong, and the Canadian Chamber of Commerce in Hong Kong is actually one of the largest ones it has globally. We also have over 200,000 Canadian university alumni in the city. And you know, you touched upon what some of these regulatory changes have been and a little bit on the impacts on society, but I was wondering if you could talk more concretely about what these changes in Hong Kong law and perceptions of national security will have on the operations of these organizations and on these individuals. Will this change their operational risks? And really, how do you characterize the current environment for these entities?
Yes, thank you, Elizabeth. I'm sorry that for the 20-minute presentation, it may not touch fully upon the impacts of the Canadian friends. But I guess 2 lessons that we must learn from the case of Hong Kong. And first of all, Hong Kong is different from Canada. Canada is a sovereign state. It has a bilateral relationship with China. But Hong Kong's status is not bilateral against China. It is a special administrative region under the PRC. In a way, China is another sovereign state after the British government. on Hong Kong. So highlighting the importance of sovereignty is essential to the Canadian community because you are not alone. Even if you are working in Hong Kong, even if you are studying in Hong Kong, you should also ask your government, your lawmakers to be robust in upholding constructive bilateral relationships with China. And on top of that, the second lesson I would say is Hong Kong's is converging into the mainland's governance model, including the legal governance, including the status of legality in Hong Kong, in a way that boundary risk remains. The red line is always shifting, and now we can see the executive branch has almost unlimited power, that they are almost being unchecked by any bodies, any institutions in Hong Kong to exercise power in the name of safeguarding national security. So there are many new regulations and new laws. For example, they have empowered the police under a new amendment of implementation rules of national security law for that local police can request for any device access in the name of national security. So privacy rights is always undermined and being limited. Now they can even qualify legal professional privilege powers in Hong Kong. In the past, companies has always been able to use legal professional privilege to defend their clients' materials. But now, if they have to use the legal professional privilege powers to protect materials against any request for information for national security investigations by the authorities, they are much higher threshold for the lawyers and for the companies to justify the use of legal professional privilege. So there are lots of detailed arrangements and amendments now in Hong Kong's regulatory regimes, but the key lessons are still essential. Namely, one, the sovereign power is always existing. Is always existing. Secondly, the boundary is always shifting, and the executive power and the law enforcement power has been expanding against all these uncertainties.
Just to sort of pick up on that thread where you're talking about the executive authorities are always expanding in Hong Kong, you're referring to the chief executive office, correct? And not necessarily Beijing. And I'm wondering if you had any sort of observations on how that relationship sort of is evolving and the scope of the CE's office vis-a-vis Beijing, and how that might be playing out in Hong Kong's business environment in particular. Are we seeing the chief executive acting more conservatively so as to maintain favor with Beijing, or are we seeing something different there?
There is a lot of uncertainties in terms of governance in Hong Kong, and one main issue is that the system has been further closed than before. I'm not praising in the past Hong Kong has the best system. Hong Kong's chief executive has never been democratically elected by the public. The government is always undemocratic at all because there's no general universal suffrage, or even I would say China does not appreciate such so-called Western models. But in the past, there were still independent bodies, independent institutions remained. The judiciary can conduct judicial reviews to check against government's misuse of power. There was other independent bodies, say ombudsman, say equal opportunity commissions, as well as there is a statutory independent inquiry commissions on the law book in Hong Kong. That the government could invoke it for some independent and general investigations of government misconducts. And the legislature was used to check and balance government power when lawmakers also have the power to investigate or to review certain matters related to government conduct. But all these institutions nowadays, they are succumbed to the national security agenda. and they have no way to challenge or to review the use of executive power in a meaningful way. The court are no longer able to review any acts of the National Security Committee in Hong Kong, which is the top supreme body in Hong Kong, led by the chief executive. The legislature was reshuffled that no opposition lawmakers could generally enter into it. And now we can see most of the lawmakers have a mainland Chinese capitalist background. Many of them have been working in the so-called red capital in the past. And all these settings tells us that even under undemocratic governance model in the past, there is still some robustness of independent checks and balances. But now all these independent bodies are gone. I can give you a quick example about the recent tragic fire in a local district in Hong Kong 6 months ago. And after the fire, the government refused to set up a statutory commission of inquiry to investigate on the matter. They have their reasons. People could dispute with it. But in effect, now the government have another investigation committee which does not have a statutory power. And it could not accommodate the local grievances on that. And the lawmakers have been silenced, that they are not eager to discuss or debate on the matter in the chamber. But in the past, lawmakers would be eager to engage in such investigations in support of their constituents. But all these formal practices, former liberal and democratic practices are now gone. And the impacts for our friends is really clear, that even if you are working or investing in this city, if you get troubles and this trouble is sourced from some institutional drawbacks, you have no ways to amend it. You have no ways to provide remedy because you don't have a balanced power mechanisms in Hong Kong.
Okay, and I want to keep going down this rabbit hole here because you keep saying so many interesting things. So you mentioned that a lot of the lawyers that are involved in legal professional services in Hong Kong now have extensive experience in the red capital work. So meaning they've been advising firms in mainland China, which has been long acknowledged as having a very different system from that of capitalist markets and rule of law nations such as Canada. One of the trends that has been well noted in the mainland is kind of this bifurcated legal system where commercial disputes and there's far more certainty when it relates to legal matters that are purely commercial in nature. Whereas when things become quote unquote sensitive or political, there is a completely different type of legal system that's being applied in those circumstances. Now, there's sort of two elements to this with the expansion of the concept of national security and the moving of lines that you mentioned. What can become political in mainland has always been very blurry and been a bit of a risk. But what I hear you saying now is up until recently in Hong Kong, that line was there really wasn't a line. The legal system was very reliable in a way that most organizations in places like Canada legal system or the UK legal system would find familiar. Are you saying now that this system is bifurcating in a similar fashion to what is like in the mainland, or is it something different? And if it is bifurcating or becoming something different, is the risk not higher for companies that have been operating in Hong Kong under this kind of legal certainty that has now rapidly transitioned or changed for them? So two questions.
Right. I was referring to lawmakers in Hong Kong nowadays in the latest cohort. Most of them, many of them have been found that they have a red capital background. And for many lawyers in Hong Kong, of course, especially for solicitors, they have a lot of chances to access to clients from the mainland. And they have to deal with a lot of IPOs. Maybe these initial public offerings are requested by mainland companies trying to be listed on the equity markets in Hong Kong. And in the past few decades, China has opened the legal service market to Hong Kong, both solicitors and to barristers. Barrister could be a legal advisors in mainland's law firms, or to be a legal advisor in mainland's market. And all this opening of legal service market, on the one hand, of course, is favorable to capital flow, but on the other hand, it also creates a new norms of censorship or self-censorship, because they do not want to provoke or to provoke their mainland clients. And ultimately, if they want to keep the relationships, a good relationship with mainland clients, they have to build a good ties with mainland's lawyer associations, or to build a good ties with authorities from the mainland. And this political economy has been sustaining the conservativeness of the major legal service industries. Of course, I'm not undermining that there are lots of lawyers who are eager to be critical and to keep their liberal values in public. That I also include my observations on this group of critical minority in my book. But having said that, the legal certainty and the market opportunity has been working in parallel. And such political risk and political sensitivities has become an inevitable norm if for anyone who want to engage in economic activities in China. And such norm are unfortunately expanding into Hong Kong because of the new uncertainties from the institutions. And when you I hope this answers the two questions. But if I want to add, if I'd like to add on, I would suggest is still important to understand. It's still important to have informed decisions when you try to engage in economic activities or investments in both Hong Kong and mainland, and especially in Hong Kong. Even though Hong Kong's model is converging into the China's model in terms of governance, in terms of all forms of so-called assimilation. But Hong Kong's investing in Hong Kong could be more uncertain than in the mainland, mainly because Hong Kong is still entering into the mainland governance model, and it seems in the past few years most of the lawfare and political suppressions, or even social control and the practice of censorship and surveillance, are trying to showcase that Hong Kong could be a loyal city to Beijing. And there is always a phrase that I often used is, if you want to show that you are obedient, you have to be more patriotic than anyone else than in the mainland government. Or some may say, in a term with all respect, is sometimes you may have to be more Catholic than the Pope, because you need to show to the authorities that you are patriotic enough, that you can be part of them. And for some people may say it's a way to gain trust from the Chinese authorities, but the cost will be very high, because when you are trying to move on that trajectory, you will lose what you have been earned for decades. Say the rule of law, say market freedom, say international reputations, because of the robustness and independence of these institutions.
Mm-hmm. Sort of, going down with this idea of Hong Kong's legal system being assimilated to that of the PRC, do you think that it's going to be sort of a holistic assimilation, moving away from Hong Kong's common law system? And one of the other things I was wondering if you could talk about, because it's not often discussed in these kind of circles, is the Greater Bay Area and the Greater Bay legal framework. So there is this new, well, I guess it's not new anymore, but there is this legal professional examination that is creating almost a hybrid legal system where lawyers in the PRC, which is a civil law system, can be moving and practicing in Hong Kong, and then similarly, Hong Kong lawyers, if they choose to, could be certified to practice in the PRC. But it's my understanding that not a lot of Hong Kong lawyers are availing themselves of that because of the tremendous number of PRC mainland lawyers that are already in existence and know that system quite well. So I was wondering if you could talk a little bit about that and how this Greater Bay area legal framework might impact companies and organizations, say from like Canada, as they're trying to navigate this new hybrid?
Right. Perhaps there are two questions. For the first question, well, whether the common law could remain or could still exist, of course, whether a system could exist is more on is more depending on the imperative from the top. And President Xi has already been repeatedly suggested that Hong Kong should keep its own common law system. But what is the substance of the common law system matters more than the form. Even though we can keep the formality of the common law system, the substance has gone, which is the protection of basic rights and liberties, the fair trial, due process. And if one loss of protections of fundamental rights, maybe the next step would be the loss of property rights. And how do we ensure the system could remain robust and remain as a guardian of individual rights and freedoms? That I guess there would be a big question. And if such common law system could not protect the substances of where the system come from, then what is the purpose and what is the meaning of the formality? In the past, there are many authoritarian regimes that are also using the common law system, or a hybrid regimes using common law system, like Singapore, Malaysia, or even South Africa during the Upper Fields time. I guess what matters is the substance. And for the second question, the Greater Bay Area, I hear you are referring to the lawyer examinations, and I don't have the latest data on that, but I guess drawing a parallel to the early days when China decided to open the legal service market to attract the Hong Kong lawyers to engage or to create a kind of a mutual opening of the service markets, there is still a way for, there's still some attractiveness for local solicitors or even local barristers to enter the mainland service market because of economic opportunities, business opportunities. But I guess what's more important is the cost, because for China, economic opportunities also mean political infiltration. It also means extracting political influences of that. It's always about the political influences combined with market opportunities rather than purely trade and commerce. And I guess such opening of the examination in the Greater Bay Area follow the same logic. They want to incorporate and assimilate rather than simply providing economic treats to our friends in Hong Kong. And that will also relate to how we understand the role of Hong Kong in the Greater Bay Area. Of course, if foreign investors who want to engage in the legal service in the GBA, I guess the most obvious reasons is that it may be cheaper than other jurisdictions and other common law jurisdictions. But but to what extent engaging in the GBA's legal service market could ensure quality control and can ensure recognition, I guess this is still way to see, and I won't give a very clear yes or no for now.
Mm-hmm. This actually leads us into one of the audience questions. So maybe we'll do a hybrid approach where I'll ask an audience question and then I have one or two more of my own, but we have a lot already coming in. So I'll just read this question out. Thank you, Dr. Lai, for your description of how Beijing uses the legal structure and new institutions to affect HKSAR political landscape. Could you further describe how this erodes the autonomy of HKSAR as defined by the U.S. State Department? Additionally, are there certain red lines that would exclude HK Court's decisions from common law precedent?
Thank you for the question. Unfortunately, I don't have a clear understanding of how the U.S. State Department defines the autonomy of Hong Kong. But what I could draw a comparison is that before 2020, before the imposition of national security law, the Hong Kong's courts has a high autonomy to determine or to adjudicate constitutional reviews or administrative reviews where governments may be alleged of misconduct or whether certain government policies or legislation are unconstitutional at all. But after 2020, in Hong Kong, the courts are unable to review any acts of the government related to safeguarding national security, and the courts were not able to challenge or to question whether a matter relates to national security. Because on the one hand, the national security law empowers the chief executive to certify any acts or any actions or any materials are related to national security, and the court has to comply with it. And on the other hand, the courts evolve a jurisprudence to suggest a principle of judicial deference, that the court should not judge on any matters related to national security and should leave the judgment to the executive authorities, and the court just follows it. And this is a misuse of this principle because there is a one caveat that the local courts in Hong Kong is significantly missing. That is, in other common law jurisdictions, judicial deference was used on the condition that there is a democratic accountability of the government. If the government makes mistakes in national security matters and the court followed it, then the government and the cabinet could be punished by the public in the next elections. But it wouldn't exist in any authoritarian regimes. So I guess this I'm not sure whether I answer your questions directly, but I guess that is how the erosion of autonomy exists when judicial autonomy, where independent judiciary has been losing its power to check and to prevent any government abuses of power.
All right, and so when the questioner was asking about red lines, I mean, I think the clearest red line is around national security, but what's problematic about that is national security is defined by the PRC, and as you were mentioning earlier, these new regulations in Hong Kong is expansively defined. I think, comprehensive national security as a concept in the PRC has 15 different vectors that include food security, cultural security, as well as, traditional national security concerns. So that's the clear red line that's super blurry. But that leads to, sorry, go ahead.
No, I just want to reiterate at the beginning of my presentation, I referred to the 2026 white paper on Hong Kong. The white paper was introduced by the State Council in the PRC, and it does highlight new areas of national security, including economy, finance, shipping, as well as other key economic and development areas that nowadays in Hong Kong, they are areas of national security. They are not just trade and commerce or market activities. Yeah.
Right, which is kind of interesting when you think about the fact that Chinese cranes in U.S. ports and even in some Canadian ports have been considered a national security concern in Beijing. Rosa stink about that, but let's not go down that path because I wanted to ask and stay in the legal realm and not ports. So you've been talking about the erosion of judicial autonomy, and Canadian courts and U.S. courts and UK courts have often been asked to recognize or enforce Hong Kong legal proceedings. Does this erosion of judicial independence that you're describing change how these courts should approach that? And I'm thinking in particular, there's recent court cases out of New York State that have really shown great effort in civil matters to just enforce Chinese court decisions, even if there is some sort of political motivation, because the courts in New York have said that they don't essentially have the capacity to dive deep into every single civil litigation matter that involves enforcement of a Chinese judgment. So are we at a point where we need to be having a discussion about how Canadian courts need to be treating Hong Kong judgments?
Of course, under the common law tradition, under case law tradition, usually judges would refer to precedents from different common law jurisdictions, and Hong Kong should be part of it because we are in one common in a common law family. But I guess it's more important to be pragmatic in the sense that for many criminal cases related to national security or to public order in the past few years, they have been treated or they have been considered as disproportionate punishment, or the convictions was not adjudicated in a fair manner because of the national security settings. And therefore, even the Canadian government has suspended the extradition agreement with Hong Kong. And as news reported, Canadian authorities have also accepted political asylums from Hong Kong who were convicted in different criminal offenses under Hong Kong's common law system. Say there were national security defendants, and there are also protesters in 2019 protests. Now they have been given asylum status in Canada. So I guess we should be pragmatic in the sense that it should be case by case, but also the authorities should recognize the institutional the institutional drawbacks in Hong Kong's legal system nowadays. That in national security cases, the system is not as robust, as independent and fair than before. But on other matters like civil cases or commercial cases, they may need to recognize this on a case basis or case-by-case basis, because even nowadays, the Hong Kong government is also using the civil procedures to introduce national security related elements in it. So the duality or the binary between commercial court and criminal court, between the civil court and the criminal court, is not as clear as before.
Great. That's an excellent and comprehensive answer. And I keep throwing two questions at you at the same time. So maybe now we'll shift gears, and I will only ask one question. This is one that we received from an audience member in advance of this session. And this is a reminder to everybody in the audience. You can also send us questions before the session to make sure that they're asked. So this person is asking, how can we ensure the safety of Hong Kong dissidents abroad and keep China accountable for extrajudicial overreach? Because I know you mentioned in several of your slides the expansion and extraterritoriality of Beijing legislation as well as Hong Kong legislation. So how does this apply to those who have fled Hong Kong in the aftermath of 2014 umbrella movement and the 2019 anti-ELAB movement? And others.
Thank you. Thank you for the question. I appreciate that. It's also important to highlight the needs of the community from abroad, because all these, whatever they are new immigrants or they are asylums, they are part of the community of their new home. In the context of Canada, you have a lot of Hong Kongers studying, working, and living in the territory for decades. Even some of them have been arriving in recent years because of the political pressure from Hong Kong. And it's important for all host governments to treat these new arrivals as part of their family. And as I mentioned earlier, one distinction between Hong Kong and Canada is, of course, the issue of sovereignty. Canada is a sovereign state. Hong Kong is not. And Canada should have its bargaining chip, have its sovereignty to negotiate with any foreign countries if they are attempting to influence the local affairs in an illegitimate or unlawful way. And we have been talking a lot of transnational repression or foreign interferences in many different occasions. But I guess more importantly is what are the operational actions? What are the practical actions for the Canadian government, ranging from the national level to the provincial level to the city level, to protect the citizens? And one practical solution is to ensure these new arrivals could have their new status as soon as possible. And to allow them to become Canadian citizens is a way to ensure the government responsibilities on these people and these new citizens' obligations to the government. And it creates a stronger bonding to back up the government to negotiate with any hostile authorities, including China or Hong Kong or any other authoritarian regimes.
That's a great point, and unfortunately happening at a moment in time when globally we're seeing restrictions mounting on immigration systems. Most recently there was this effort in Switzerland to cap the number of Swiss citizens that there are. But sort of moving over to another related question from an audience member. What should be done to help Hong Kong dissidents if they are in countries that have legal extradition agreements with the PRC?
Um, Yes, thank you for the question. There's already rulings in the European Court of Human Rights that extraditing criminal suspects to the mainland China would violate the European Convention on Human Rights. Although this could only bind countries ratifying the ECHR, but I guess other countries, the courts from other jurisdictions should also take it as a strong reference point. And I guess one critical issue is whether such ruling could also be applicable to the situations in Hong Kong. And I guess it needs more developments, it needs more discussions and jurisprudence to be developed in different courts. But there are a lot of existing materials to argue Hong Kong's legal system has becoming worse than before. And they are evidence-based. And even some government policy papers, including the UK government's Home Office country notes on Hong Kong, China, has acknowledged that. So I guess more information and evidence are needed, and more systematic legal analysis is essential to inform policymakers, as well as to inform judiciaries from different jurisdictions about the status of Hong Kong.
But that's interesting that you point that more legal analysis on this difficult issue needs to be undertaken. When you mentioned earlier in the discussion that you're seeing almost self-censorship within certain legal profession, certain elements of the legal profession, as they're trying to support their clients still maintain access to the mainland. And I'm wondering how that balance might achieve. Are you suggesting that it needs to be legal analysis of lawyers in other jurisdictions that need to be doing this? Civic associations and civic rights associations need to be paying more attention to this?
Yes, I indeed, what's most worrying in my personal view are twofold. One, once we treat Hong Kong as illiberal or autocratic jurisdictions, then people are not interested in studying the verdicts anymore, because they may think all these verdicts are nonsense or irrelevant because the system is authoritarian at all. Another worry that I have would be that people would still feel such legal verdicts or legal judicial decisions are so technical, so comprehensive that local people could not understand. And not to say journalists or lawmakers or policymakers. And I guess to make all this legal information accessible to the public is still significant. I prepared some slides on that, but I could share it now. Is in a way, despite all this unfavorable and restrictive environment, more important is to ensure access to information, including legal information like court judgments, court verdicts, judicial decisions, and legal commentaries, legal opinions, because all this information are enabling and educating the public and the policymakers and stakeholders about the status of the rule of law in Hong Kong. It's always easy to give a blank criticisms on Hong Kong's court just because it's now backed by the authoritarian system. But there are still a lot of caveats and a lot of detailed information that we could still analyze and investigate in order to provide alternative solutions, or to provide dissenting opinions, or in the future, this could be important resources to improve the cost performance, to improve the quality, and eventually to correct and amend the system at all.
And I think that that's a really great point that you're making here that I just want to underscore, is that you can't ignore judgments and what the courts are doing, even in an authoritarian state, because that's the whole premise of lawfare, is it's finding different ways to manipulate legal systems in order to be weaponized or achieve political ends. And we have to pay attention to what's happening in those courts, even if they don't mimic what's happening in our own. So I really like this point that you're bringing home, and I've probably just butchered in my inarticulate way of describing that. But moving down further to more of your recommendations and analysis, we have another individual who's asking, and this is a tough question here for you. Many researchers and those that work in higher education put their academic freedom above everything else. So if you, Eric, as a professor, if you were to have 3 minutes with a university president in Canada that thinks they must expand their academic partnerships with universities in Hong Kong, how would you explain the risk on a Canadian university without being labeled a China hawk? And I think this brings up a lot of issues that are, present right now. Is having a discourse on the PRC almost gets shunted into two different binaries. It seemed very binary. You either totally pro-China or totally anti-China, and there's no room for nuance. So, again, 3 minutes with a university president in Canada, how would you sort of advise them in their strategy with Hong Kong universities?
Right. I hope you are not counting down, but I guess one important issues of academic partnership is what are the protocols or the provisions of the MOUs refer to. If it is about academic partnerships of exchange, that must include sharing of data, and how and where should the data be stored in a secure way is always a big issue. And recently we saw researchers as long as a journalist also arrested in mainland China when they are seen as academic. And there were also many instances that business executives were arrested for espionage activities in the mainland. And whether it will happen in Hong Kong, we have no idea. But the laws in Hong Kong nowadays make clear that the definition of espionage, foreign intelligence, they are almost identical with mainland's espionage laws. So among this legal risk, this data risk, how would such academic partnerships can manage or to safeguard and to mitigate such risk? That I guess there's more about detailed discussions rather than ideological privileges. And the second issue is whether and how academic partnerships between this university can ensure academics, researchers, or teaching staff could safely travel to Hong Kong and back to their home country, and whether their electronic devices would be arbitrarily requested for access, whether their fieldwork, their research work could safely carry in Hong Kong, even if they are doing sensitive topics to China. And I guess these are all practical issues and practical steps that any academic partnerships should be considered. Recently, there are some international academic association planning to do an annual conference in Hong Kong, and it is important. More important for audit and due diligence rather than simply giving an answer of do it or don't do it. And without such auditing processes or due diligence processes, it will be very risky for any institutions, whatever academic institutions or business institutions, to have their partnerships in a country that legal certainty is at risk and boundary risk is increasing.
Yeah, and I think that this idea of boundaries is really important and often overlooked. Institutions really do, and organizations at large need to have very clear goals about and objectives about what they're trying to do through these partnerships and establish very clear red lines, because as we were talking about earlier, it's these blurry lines are the tool of authoritarian governments because they give you wiggle room to put in your sort of political biases and interests ahead of other things. If you have clear red lines, such as teachers will be allowed to address whatever topics they want, and their statements will not be vetted beforehand. It is a red line that I've heard a lot of professors use when they've been asked to travel to conferences in the mainland or in Hong Kong. So just having those be upfront, and the importance of transparency is also really critical here, making those red lines transparent to everyone so we all have our expectations about what will happen and what won't happen.
Yeah, I guess more preventive risk assessment and mitigation plan is a way to minimize the chances of crisis management. And I guess it applies not just to academics, but also to the business sector and even to policy sector. You don't want to deal with a lot of crisis management or mistakes, but rather you want to mitigate or minimize the risk in order to keep not just the reputation, but also the safety of your own colleagues and your own people.
And this is something we spoke about on a panel you joined APFC on back in March. And for those of you in the audience who haven't seen it, it is uploaded on our website. There is a reference to toolkits on these sort of preventative measures. Now we are almost at time. These sessions always go so much faster than I hope, and I apologize to those whose questions have not been asked or answered. But I did want to give you one final question, Eric. It's a real simple one. But if there is one thing you want Canadian policymakers, businesses, or civil society to take away from Hong Kong's experience, something that isn't getting enough attention perhaps, what would that one thing be?
It's really, for me, it's really about caring for the people. We have seen a lot of drawbacks of governance in Hong Kong. The lawfare in Hong Kong was also aiming to target individuals, to target the people they disapprove. And caring for the people, for the community, including Hong Kongers in Canada, I would say is the most important policy agenda. It shows a value-based governance, a value-based diplomacy to its counterparts. They are not simply caring for capital, but they are caring for the people.
Well, I think on that very uplifting note, we'll close today's session. It might end up being a little bit early, which I think if you don't have any final reflections, maybe I'll give you one more minute if you want. I know I've been rushing you.
Yeah, I thank all these opportunities for the sharing and exchange, and I guess we have a lot of commonalities between the Canadian experiences and the Hong Kong experiences, especially there's an early wave of migration from Hong Kong to Canada in 1990s. And the background was also on a political event, a political tragedy, the Tiananmen. And after 2020, loads of Hong Kongers relocating from Hong Kong to Canada on a similar political background or political tragedy. So I guess these shared experiences, these shared commonalities between the two generations of Hong Kong immigrants in Canada should be the good lessons for our friends in Canada on the impacts of how authoritarian regimes impact its people and eventually impacts geopolitics at all.
Wonderful. Well, thank you so much, Eric. This has been an extraordinarily rich conversation and exactly the kind of deep and thoughtful analysis that Canadian policymakers and businesses need to be engaging with and taking more seriously, and also a very helpful reminder of the deep ties that Canada has to Hong Kong in particular. I want to also thank everyone in our audience who joined today, and especially for all of the really excellent questions. Again, apologies for not getting to all of them in our short amount of time. As mentioned at the top of this presentation, we will be sending you a feedback survey after the session. We really do ask if you could take 2 minutes to fill it out. We read every response, and your input can genuinely shape where this series goes next. On that note, we will be back in 1 week time on Tuesday, June 23rd at 1 p.m. Pacific time, 4 p.m. Eastern, with Asia Pacific Foundation of Canada distinguished scholar Pittman Potter, who will be drawing from his forthcoming book, China and the Rules-Based International Order, to examine how the PRC engages with international institutions and norms, and what that means for middle powers like Canada. And I think, Eric, this nicely picks up on the values approach that you ended your session on. As a final reminder, this session will be posted on our website along with a written summary report. So please do share it with your colleagues who are unable to join. And with that, I think we will close out. And another big thank you to you, Eric.
Thank you, Elizabeth, and thank you, everyone. Yeah, have a good day.